Right. Good evening. So this session we are going to just do one thing. We have one essay question in a form of a memo, and we would like to spend a few minutes trying to look at how such a question will have to be approached. So the question I am dealing with is the a typical essay question. It goes like this. So I'll read the question and then we do the discussion. The law relating to recovery of payment under illegal contract is unsatisfactory. The Law Reform Commission of Ghana is requesting for suggestions on how to reform this area of the law. Submit your memorandum to the commission. So, looking at your law school entrance examination pattern, this is a typical way in which you can have an essay question. But if you look at this question, you notice that, of course, it's quintessentially, it's basically an essay, but the question tag master could sometimes deceive you and let you lose focus. And that is why some of you get worried when, for example, they see questions having things like send a memorandum, draft an opinion, and things like that. Then they get very confused. It shouldn't be at all. And as I've told you before in some other sessions, either last year or so in some of the recordings, what you should remember is that this paper is still considered LLB standard. You are not in a professional law school. You haven't done drafting and so on as a course. So in terms of the technical requirements of drafting style, you shouldn't worry so much. Just focus on the substance of the question. So for example, assuming that you have a question like this, that you are supposed to send a memorandum to the commission, that is the Law Reform Commission of Ghana. Yes, typically, if you are doing a memorandum, you have this format, like a memo or memorandum, who is writing, you put your name there from, and then who is the intended recipient or addressee or the audience, so the Law Reform Commission. And then what is the subject? What are you writing about? So the subject, that is what you are supposed to be communicating to the recipient here, the Law Reform Commission. What are you going to tell them? So that is what we call like the subject. So if you look at this question, for example, of course, what I have put there as a subject is not the only way in which you can frame it, but I think it's a sensible attempt to capture the heart of what we are also directed to do. So, like in the sample, I just stated suggestions for reforming law on recovery of money under illegal contracts in Ghana. So, the subject is like the title, the title of the paper. Yeah, so I'm sorry, the line went off again. The subject is the title, the topic of what you are writing to the Law Reform Commission about, as it were. So therefore, let me just expand it so that you're able to see. Yeah, so The screen has disappeared. Let's hope it comes. I think we need the screen sharing again. Okay, so good. So you have your heading out there, and as I told you, the fact that I have framed it the way that we have it here doesn't mean that that is what you should all do. But what you should remember is to read the question and understand what the question is inviting you to. So once you understand what the question is asking you to do, you'll be able to capture what ought to be like the title for your memo. So let's, for example, work with what I have put here, suggestion for reforming law on recovery of money under illegal contracts in Ghana. Now, don't forget that despite the fact that we are told to send a memorandum, it is still an essay, okay? And in any good essay, any good write-up, you need an introduction. That is the opening. So we are going to have our introduction, and in the introduction to an essay like this, we must state or declare the purpose for which we are writing this particular particular memo that we have set ourselves to write. So what is the purpose? We have to indicate it, and then we must also give a structure, like a structure or the roadmap of the points that we are going to canvass in the memorandum. And of course, when we are done with the introduction, we go to discuss like the body, and then we have like a conclusion. So in terms of like the body, for example, I think that three main things may be touched upon. The common law position on consequences of illegality, then the problems inherent in the common law position, and then the suggestions for reform based upon the Supreme Court decision in City and Country Waste Limited against Accra Metropolitan Assembly. And then, of course, you have your conclusion. So this is the answer plan. So without wasting time, let's attempt to expand each of these. So in terms of introducing this memo, as I've indicated, we have to declare our intention. Why are we writing? This memo has been necessitated by the interest or the invitation by the Commission to generate as many ideas and suggestions as possible to reform the law relating to recovery of money and illegal contracts. And this is a very good time for such a project to have been embarked upon by the Commission, especially so when we cast our minds back to a decision which the Supreme Court gave around 2007, in which the highest court of the land came face to face with the unsatisfactory nature of the law relating to recovery of money or payment and okay. Yeah, so we're just trying to build some ideas for the introduction. Now, yeah, so having said those things I said before, there was that connectivity interruption, then we make the point that in this memo, you propose to share some few ideas or suggestions which could shape the reform which the Commission is embarking upon. So you shall do this first by stating the common law position on consequences of illegality, and then attempt to identify or discuss the problems, the challenges inherent in the common law position as far as recovery of payment under illegal contract is concerned. And then you will now proceed to make specific suggestions as to how the Commission may proceed in trying to reform or make a recommendation for legislation to reform this area of the law. So here we finished our introduction, and one thing you have noticed is that in this introduction, we have declared our purpose of writing the memo, our intention, and we have been able to situate that within what is going on. What is going on that the Commission is not satisfied with the state of the law relating to this particular area. And again, we've also given an idea of the kind of things that we intend to discuss or we intend to explore in the memorandum. Now, we are moving on to our first sub-theme. And let me also say that there is nothing wrong for you to give headings, right? Like I have done as you try to develop the memo. Assuming, like, so what we have here, for example, could be a convenient structure, assuming you are writing a response to a question like that. And the advantage of such structured approach, like trying to give these sub-themes, is that it does not only enhance the layout of your answer, it also helps your examiners or your markers not to struggle to be able to identify exactly what you want to talk about and form a judgment. So that is important. And don't forget that your markers are grappling with a lot of scripts, 1,000 or 500 or whatever script. So how you also present your ideas to aid faster reading and assessment is also important. Good. So let's take the second point from our answer plan and then discuss it. Of course, we need to make a sentence or two regarding what an illegal contract is before we even proceed. So we know that, and let me say that in case you have forgotten illegal contract, I think I've done one or two episode or presentation on illegal contracts previously, and they are all on the YouTube channel. So you can just search for it and play it back. And there, I have done a very detailed and linear presentation on the whole topic of illegality. But what we are doing here is just trying to think through how to answer a question on illegality. And that is why I'm not going to be very detailed as I was in the presentation that I did, and the video is also available. Now, so taking point 2, as I said, it will be useful for us to explain that an illegal contract is a contract which has been entered into or concluded either in defiance of a statutory provision or a known public policy, or a contract which was not necessarily illegal at the inception, but its performance is tainted with illegality, maybe due to some subsequent developments after the making of the contract and all that. So here you have at least made effort to explain to your examiner your understanding of what an illegal contract is. You are now going to proceed with the proper discussion of the point 2. So therefore, where it has been, if maybe a good student will, for example, maybe give 1 or 2 illustration of when the court concluded that something was an illegal contract. Remember the case of Pierce and Brooks and so on. You can cite some of those to illustrate. And then you go on to make the point that where the court has concluded at common law that a contract is tainted with illegality, then ordinarily speaking, the courts will not allow recovery of money paid under it. The only exception which developed at common law was that where it could be demonstrated that the parties were not in pari delicto. That is to say that they were not equally at fault as far as the illegality is concerned. Then the court may allow some recovery under very limited circumstances. But again, if you go to read the full case of the Supreme Court, as I've told you, in City and Country Limited against Accra Metropolitan Assembly, and if you haven't read that case, I will urge you to read the full judgment, because assuming, of course, I'm not saying that there'll be any question like this at this stage. Nobody knows any question, but it's just wise if you come across any question for you to think through. Who knows if that is what will be the magical question for you. So I will encourage you, if you haven't read the City and Country Limited against Accra Metropolitan, go and read, because you read it. Justice Owusu-Dapaa and his other brethren will actually go to town to expose the unsatisfactory nature of the common law approach as far as recovery of money under illegal contract is concerned. And the difficulty, the common law was that it was so harsh that if you could not actually bring yourself within that very limited exception to say that you and the defendant were not pari delicto, and for that matter, the court should create some kind of exception for you to make a recovery, or where they say that the illegal contract can actually be severed from the rest of the contract, then you'll be allowed to recover another. These were quite strict, and there are situations where these exceptions will not really avail and there'll be injustice. So if you go back to the City and County Limited against the Accra Metropolitan Assembly, you notice that a contract for waste clearance or removal had been made between the plaintiff and the Accra Metropolitan Assembly, and the mode or the manner in which the contract was concluded was actually in defiance of statutory provisions of Accra Metropolitan Assembly. So the contract was made not in strict accordance with the procedures or the rules or the regulation which govern award of contract by the Accra Metropolitan Assembly. But the truth of the matter was that the city and country waste had actually been providing significant service under the contract. And when time came for payment to be requested and all that, then they are met with the defense of illegality, that this contract that you are seeking to recover payment under was actually concluded in defiance of or in breach of statutory requirements for making a contract involving the Accra Metropolitan Assembly. For that matter, it is illegal contract and you cannot recover. Now, this is the common law position. This is the common law position. So if you are to go swiftly by what the common law was, yes, you will say that the city and country waste should not be given any payment for the work that they had done under an illegal contract. But then the Supreme Court looked at the matter closely and said that we also know that the law does not encourage what we call unjust enrichment. Unjust enrichment is where you have received benefit at the expense of another person when you've not done anything in return to that person. So as the Bible says, it's like you are reaping at where you have not done, you've not sown. So that is unjust enrichment. Now, where there is an unjust enrichment, you could actually bring an action for what we call restitutionary claim, so that the court will restore you to a level where the unjust enrichment that you have suffered at the hands of your opponent will have been reversed or corrected. But at common law, where you are bringing restitutionary claim under situation where the unjust enrichment you are trying to correct came about because the contract had been declared illegal, you will still run into difficulties, because the person against whom you are bringing the case will say that, well, there was no underlying illegality, and for that matter, the court should not entertain your claim. Now, the Supreme Court said that if you look at the common law, it is not really fair in these circumstances. Let's look at, before we even let's look at this closely. If you take like a government agency like the EMA and so on, doing a contract. Now, city and country, do they have any power in terms of ensuring that all the proper things are done? Of course, those of you who've done company law, remember the indoor management rule and so on. And of course, those of you who also remember your evidence law, presumption of what? Regularity. So when you are dealing with the, let's say, the EMA and all that, probably you could make those assumptions, but that isn't what we are talking about. We are talking about where the court has actually concluded that the underlying contract was illegal. But then the court is also mindful of the fact that significant work has been done under the illegal contract. And if you have to put money value on it, it is so substantial. So therefore, do we allow ourselves to be blinded by the illegality principle and say that AMA should hold on to all the great work which the city and country waste had done under that contract? And then city and country waste is not going to be paid for that great work that they had done. Would that be fair? Would that be just? So it was within that context that the Supreme Court decided to look at practices developing in some jurisdictions who were also not satisfied with how the common law dealt with recovery of money under illegal contract. And that search took them to New Zealand and other places, as well as even a work with the law reform, the Law Commission of UK itself was doing. And the Supreme Court said that they are going to use what they call like a structured approach. That is to say that instead of going by the existing common law position that as soon as you establish illegality, then apart from those limited, strict exceptions, there's no way that you'll be allowed to recover any, payment, for services done under the illegal contract and all that. The Supreme Court said that no, we are not going to do that. We are going to use the structured approach so that in appropriate situation, restitutionary claim could be brought for recovery under a contract which has been otherwise considered illegal, and so on and so forth. Yeah, so when you have read the City and Country Limited against EMA, you will come to appreciate more the things that I'm talking about, and those are going to be like the suggestions. The suggestions will be that the Law Reform Commission should embrace the approach which the Supreme Court had actually indicated in this case, and allow guidelines which can be followed, so that if you judge the circumstances of a particular case, and if you look at that, the situation in that case, and if you are going to adhere strictly to the common law principle that illegal contracts should not be enforced, right? Against also the reality of that particular situation, as whether there has been an unjust enrichment. Unjust enrichment in the sense that if you are to apply the common law rule of illegality strictly and say that no payment should be made. Now, are you not going to also encourage a situation where one person will have benefited immensely under the so-called illegal contract, and yet the one at whose expense that benefit has been created is not going to get any payment? If it is that serious, it's that substantial in terms of the unjust enrichment, in terms of the benefit which has been conferred on the other under the illegal contract, then the court will be prepared to actually make orders which will ensure that payment is made, not necessarily payment to reflect the contractual rate, right, contractual price, but payment which will be enough to ensure that the other party who has benefited under the otherwise illegal contract, for example, pay commensurate value for that benefit. Otherwise, you have encouraged the situation of what? Unjust enrichment. So therefore, in conclusion, where we embrace the suggestion made by the Supreme Court and actually followed according to the facts of that particular case, we will be able to redress, most of the situations in which we use what they call the one size fit all. That as soon as you conclude that this is an illegal contract, then we don't even pay attention to the exceptional circumstances, particularly so where one person might have benefited significantly under the contract, and the other party who actually performed is not going to get anything just because they have concluded that the contract is tainted with illegality. Yeah, so I think that if you follow some of these points and also like the approach, you should be able to produce or generate answers which will make sense in terms of essay question. Yeah, so I'm going to pause here and then take any comments or questions that you have regarding this or anything before I will sign off. Okay, if there are no questions or comments. And I'll leave you.